Hello, it's so nice to see you all here. Welcome. I'm really excited for today's talk. I would like to start firstly by acknowledging that we're on the traditional, ancestral, and unceded land of the Musqueam people. Today we're going to get into a very important discussion, but I would also like to introduce myself firstly. I am a resident here at Green College. I'm a master's student in the Library and Information Studies program. And I like to help out with events. I see a lot of residents in the audience. I'm so glad they are all here. But also for those who are unfamiliar with Green College, it's a graduate residence, and we have master's and PhD students from all over studying many different disciplines. So with that, I'm actually going to hand it over to Emma, who is joined by Tracy Chapman and Gary Edmond for today's talk. We are very lucky to have the principal of Green College here and giving a talk, and looking forward to it. So for that, thank you.
Kyla, thank you for that lovely introduction. Welcome to those of you who are visiting Green College this evening. It's lovely to see so many resident members here tonight as well. Very much appreciate you joining us. I would like to begin this talk, as I do every talk, in a good way, by acknowledging that while we're speaking about a particular wrongful conviction this evening, the wrongful conviction of Kathleen Folbigg and the challenges of correcting that wrongful conviction, the criminal justice system and wrongful convictions disproportionately adversely impact Indigenous people in colonial countries, including Canada. And so the history of wrongful convictions here in Canada begins in many ways with the wrongful conviction of Donald Marshall Jr., a Mi'kmaq man who was convicted at the age of 17 of a murder he didn't commit. And who spent 13 years in prison before being partially exonerated by the Nova Scotia Court of Appeal, and then subsequently fully exonerated by a subsequent inquiry, which in many ways set the course for an indigenisation of the legal system in Nova Scotia. The Marshall inquiry ushered in widespread, really sweeping changes to the legal system in Nova Scotia, including how the Director of Public Prosecution works, including the Mi'kmaq legal system, including the Indigenous Black of Mi'kmaq program at Dalhousie University, which has produced many outstanding Indigenous lawyers who've made huge contributions to Canadian law. Donald Marshall Jr. went on to be wrongly convicted a second time after his exoneration. He was involved in an eel fishing case, which became the subject of two Supreme Court of Canada decisions in the Marshall Treaties. He was on that occasion wrongly convicted for exercising his treaty rights, so that the Department of Fisheries took the view that he had no right to fish for eel without a licence. The Supreme Court of Canada ultimately and properly decided otherwise, that he had a treaty he was exercising in that moment. And I mention that example because I think it expands our understanding of what a wrongful conviction can be. It's not conventionally understood as a wrongful conviction, but it's an application of colonial law to an Indigenous practice that should never have been applied in that way. And so I think it's important, speaking as we are on Musqueam land tonight, to begin with an acknowledgement of the disproportionate adverse impact of the criminal legal system on Indigenous people in Canada, and since we're talking about an Australian case, also in Australia. Let me turn to introduce my two wonderful fellow panellists for this evening's conversation. We've imagined tonight's conversation very much as a reflection on what it took to exonerate Kathleen Folbigg. We won't dwell on the facts of the case, particularly, or the evidence in the case. We're much more this evening really going to reflect on both the personal and professional and structural challenges of drawing attention to the fact that Kathleen Folbigg had been wrongly convicted, and of persuading the legal system ultimately to recognise that error and to correct it. Each of us has a different starting point for this case. But I want to begin with Tracy Chapman, with introducing Tracy Chapman and her enormous, immense contribution to correcting this wrongful conviction, and not least to supporting Kathleen Folbigg through the process to ensure that she was able to get to that point, quite frankly. So Tracy is a childhood friend of Kathleen Folbigg. She knew Kathleen before the rest of us knew her name. Tracy will tell you in her own words the experience of watching Kathleen stand trial and be convicted in circumstances where she expected that justice would prevail, and the realisation that it hadn't, and the commitment that she made then at that point to ensuring that justice would eventually prevail. In addition to Tracy's work in support and advocacy for Kathleen Folbigg, she is an accomplished person in many respects in her own life. She's presently completing 2 separate master's degrees, one in counselling psychology and one in autism education. She is a former teacher at the college and university level. She's been a lecturer at both of those institutions. For 30 years, she's been a volunteer in wildlife rescue and at home in Coffs Harbour in New South Wales. She cares for many animals who've been rescued, and she's got the biggest heart I know. It's a real privilege and an honour to have Tracy here with us in Vancouver for this conversation tonight. I think we both thought we might never see this day, and so I'd just like to take a moment to appreciate that we're here. My dear colleague, Gary Edmond, is a professor at the University of New South Wales School of Law. He's the director of the program on expertise in law and also leads the evidence-based forensics initiative, which is a multidisciplinary initiative that works to improve the reliability of forensic sciences, not just in Australia, but around the world. I'm a proud member of that evidence-based forensics initiative. Gary is an eminent scholar of science and technology studies and of science in law, who has also worked, and I think doesn't get enough credit, frankly, for the work that he did to draw attention to Kathleen Folbigg's wrongful conviction and to ensure that it was addressed and corrected. And so this is the first time the 3 of us have had the chance to sit on a panel together and talk about the case. It has been a very special week. It's the 3rd event that we've done this week, but this is our opportunity really to reflect on the journey, to reflect on what it felt like to advocate to correct a wrongful conviction. I also want to acknowledge, and some of you know this and others may not, that for me, my journey with Kathleen Folbigg's case began right here at Green College. When I was a resident member in 2004, setting out on my PhD, Kathleen Folbigg had been convicted approximately a year earlier. I was aware of her case as one of many cases in which mothers had been convicted of killing multiple children. The other cases, and I'll kind of move forward to the context of the other cases. Either the evidence was excluded and the prosecution was discontinued, and so that refers to, on this slide, the 2 Australian cases of R versus Phillips in 1999 and R versus Matthey in 2007. Or the English cases listed on this slide, Sally Clark, Angela Cannings, Donna Anthony, Trupti Patel, were identified as wrongful convictions by the Criminal Cases Review Commission and addressed in fairly short order. So as I worked through my PhD, it fairly quickly got to the point, I mean, Matthey took a little bit longer, but it fairly quickly got to the point where Folbigg was the only one who stood convicted. And as I set out on my PhD research right here at Green College, it was with an interest in understanding what made her case different. And an interest in a sense, actually starting from the premise that this was likely a correct conviction. How was it different from the wrongful convictions? Now, I ended up in a quite different. By the time I completed my PhD, I concluded that in fact this was another wrongful conviction. And it took far longer for this one to be addressed than it did the others listed on this slide. And tonight, really, we're going to reflect on that long road to exoneration, which begins in 2003. When Kathleen Folbigg is convicted and Tracy Chapman makes a promise to her friend that the story doesn't end there. that she'll do what she can to ensure that the story finishes in a different way. And that took 20 years, but you kept your promise. It continues, perhaps, arguably, people had more or less lost interest, I think it's fair to say, in the Folbigg case by the time I published Murder, Medicine and Motherhood, which made the argument for the first time in academic context, or really in any context, any published context, that Kathleen had been wrongly convicted. There was some degree of media interest in my conclusions. I think it's fair to say more from the perspective of curiosity that some strange academic person was prepared to argue that Australia's worst female killer, Australia's most hated woman, which both terms by which she was referred to, was prepared to be so silly, so naive, that's both words that we used, as to argue that she had been wrongly convicted. Nonetheless, that fairly quickly turned as, for example, forensic pathologists spoke out to say, no, there's a there in terms of what she's saying, to a serious public pressure to review this case. In 2013, Folbigg was able to obtain pro bono legal counsel. That was through the University of Newcastle's Innocence Project in Australia. And they commissioned additional expert reports and filed a petition for review of her conviction in 2015. By this point, she's been in jail for 12 years. Under the New South Wales system of post-conviction review, it looks a little bit different from the Canadian approach. What's necessary is for a person who claims to have been wrongly convicted to file a political petition for review of their conviction and for the governor of the state, but really informed by the New South Wales Attorney General, to order an inquiry into the conviction. That's the process, and that was the process that followed. That petition which was really all produced by pro bono, not just legal counsel, but also the experts, sat on the Attorney General, on successive Attorney General's desks for 3 years. And all three of us were involved in advocating to the Attorney General in that time period that this petition needed to be acted on. But it wasn't until the Australian Broadcasting Commission aired a documentary produced by a wonderful Australian journalist named Quentin McDermott that the New South Wales Attorney General finally called an inquiry. That inquiry, which was called in August 2018, I think we received with relief and hope. Our relief and our hopes were quickly dashed, it's fair to say. We'll talk a bit more about the first inquiry, I anticipate, but in July 2019, after a process that contained many flaws, the first inquirer concluded that on the basis of the evidence before them, Folbigg's guilt was now even more certain than it had been at trial. It's no exaggeration to say that we were deeply disappointed and saddened by both the course and the outcome of the first inquiry, and at a loss about what to do at that point. We were fortunate, very fortunate, that an Australian scientist who'd participated in the first inquiry by the name of Criminology and the Australian Academy of Science shared our disappointment. What happened from there is something I never saw coming. The Australian Academy of Science raised a petition arguing that the scientific and medical evidence for natural causes of death in the Folbigg children was so strong that there was a strong presumption that they died of natural causes and that Folbigg should be pardoned. In fact, the petition called for a pardon. It was signed in the first instance by 90 eminent Australian scientists, including 2 Nobel Prize winners. And by the time that the petition finally closed, by 150, including 3 Nobel Prize winners. It was accompanied again by a significant kind of media campaign to draw attention to Kath's circumstances. And finally, in May 2022, the New South Wales Attorney General called a second inquiry into the case. So rather than giving the pardon that Kathleen was asking for by this point, goes to a second inquiry. That inquiry took about a year. And ultimately in June 2023, Inquirer Bathurst delivered a memorandum to the New South Wales Attorney General, reporting that he was still working on his report, but that he was firmly of the view that there's a reasonable doubt as to Folbigg's guilt. Folbigg received a full pardon on the strength of that memorandum. The final report was delivered and Folbigg was ultimately acquitted, fully exonerated on the 14th of December 2023. that's still very fresh. And I suspect that you'll see, perhaps especially for Tracy and me, that the emotions associated with that are still very fresh as well. This was a battle that took more than 20 years for Tracy and for Kath. And I want to pause and acknowledge that at the centre of all of this is a young mother who lost 4 infants successively over the course of a decade, and that the unimaginable trauma of that experience was compounded by her treatment in the Australian criminal legal system and in the Australian media. That in prison, she was held in protective custody because of fears for her safety as somebody who had been convicted of offences against children. So she served particularly hard time in those 20 years. That she was offered many incentives to admit her guilt over the course of that ordeal. That throughout it, she insisted upon her innocence, even when all hope of exoneration was lost, even when all sorts of incentives were held out to her. She insisted that she had not killed her children. She was deprived of the opportunity to grieve them. She was deprived of the best years of her life. While she is now a free person, and that makes us all so very happy, there's much that she'll never regain as a consequence of this wrongful conviction. Having honoured that, tonight we're not telling Kath's story. We've given ourselves permission, in a sense, to tell our own story, our own experience of getting the case to this point. And so I'm going to turn it over now. I love this photo of you, Tracy. I don't know if you can see it. The one that was in The Guardian. To Tracy, to begin with some opening words about the role that she played and her experience as an advocate for Kathleen.
Hi, everybody. I've got to speak into this because everybody online needs to hear me. Hello, everyone online. Look, I could bang on. We were talking yesterday in one of the legal classes that, you know, I could literally probably talk for a whole semester on this case and just we could go on forever. I'm not going to do that because you'll all be asleep on the floor. But I just want to say it is hard graft to do this sort of stuff. I guess the main reason I did it, there was a moment when I was going through a train wreck of a pregnancy at the same time my friend Kath was going through her trial, and my son and I both nearly died on the operating table for an emergency cesarean in October. And basically, after all of that, he gets airlifted out. My son and myself, I'm on an IVF line, and if something on the news comes on about Kath, and some nurses start talking about what they would like to do to Kath if they had the chance. And it really wasn't nice. So unfortunately for me at the time, I'm vulnerable. I didn't say anything. So I was filled with shame, to be honest. And I was disgusted in myself because I'm normally a pretty outgoing and vocal kind of person, but I was vulnerable at the time. But at that moment, I also recognised a whole lot of other losses that I had experienced in my life, which I won't go into now. And I guess I was filled with an empathetic urge, if you like, and compassion, because I see that as an active thing, to then, you know, say, all right, as soon as I can, I'm going to make contact with Kath and I'm going to, you know, offer to help. I don't know what I can do at this stage, but I'm just going to put my hand out and see what happens. Took a very long time, took quite a few months to actually get in touch with her because she's in isolation, in maximum security, in a maximum security prison. None of that's easy. But anyway, I get her at a really vulnerable time, put my hand out, she takes it, and we're tied for the next, which is kind of nice. I guess what I did initially, and probably until this wonderful woman came along, I was very annoying to the legal teams that were involved, I must say, but I didn't do advocacy well at the beginning. I was just annoying. You know, I often say that there was a lot of adversarial dynamics in this case, but it's probably any case, any criminal case that you come across. So when I say that, I mean, you know, you've got a place in society and the system is very elitist and a bit smug, to tell you the truth. And you might offer your support, but it's not going to give you any leeway as to what you're going to contribute. It will just kind of accept what you're doing, but not give you any advice because you're not their client. And they don't tell you how you can be more effective either. So anyway, we went along probably for the first, I don't know, 7, 8 years. And then Cass sends me this one's transcript in the mail, all photocopied by hand, one by one, hundreds of pages. And she said, read this. And I did. I read it over a couple of days and I was in tears because Emma was the first person to have done what I always thought the system should have done in the beginning, which was unpack it fully and do it with do it very thoroughly and honestly, and come to a conclusion that I always thought was the conclusion the system should have come to. I was very stressed around that time because I always felt like the conversations I had in the adversarial framework was about winning and losing, not about justice. So I was relieved when I saw Emma's stuff. And then from there, we start to get, like you said, curiosity, but there was some really good coverage. We've got 60 Minutes, Tara Brown, yeah, and Joe, God bless them. They did this amazing piece. I'll never forget that night. You know, it was in the times of unmoderated social media, and there was nearly 3,500 really awful, I'd say, violent, graphically violent comments of what should happen to me and Megan, my other friend online, and Cass. And I was shocked. I did openly say that several times online to people saying, you know, my friend's in jail and she wouldn't even think like that, you know. But anyway, we kept going and then the process picked itself up. But I don't know what else to say. I mean, we could literally bang on for hours here. But I guess what I've learned over the years is that, yeah, it costs a lot and it's really painful emotionally to be an advocate, but there's so many benefits in this if we can keep that fire burning, you know, and take note of the way things have worked, because in many cases, it's been a bit of a train wreck. So but it got better.
The case got better. I'm not sure the system did. Gary, I'm going to hand over to you for kind of a few opening remarks.
Thanks, Emma, and it's great to be here this evening. I guess the first thing I'd like to say is that it's kind of funny how you're kind of like at a deep visceral level, your perception changes, any kind of doubts you have change by kind of legal reification of guilt through the kind of, or non-guilt, because we should all be much more sceptical about, I think, conviction and guilt in certain cases, perhaps. I also wanted to just reiterate the point you made about the court, particularly the over-incarceration of Indigenous people. We're talking about a jurisdiction in Australia where this is the court, the oldest court in Australia in a continuous formation of 200 years this year. And my understanding is that there's been no apology to Indigenous people for the role they've played in the kind of that whole kind of structural series of systematic kind of bias, and so that's a problem. I came to this case, I guess, through teaching initially. It was what we'd call a coincidence evidence case. So we're looking at the improbability of 4 children dying, or something you teach your children. This is kind of a good case to get that point. Like, how should we use this evidence? And even early on, I was always amazed that the courts had adopted such a aggressive approach to the interpretation of the diaries as admissions. These kind of like these, you might hear more about the diaries, but the courts just took them all on as just complete confessional material, which it turns out that they're not that. After that, I guess, after teaching that, I was involved in the Goward inquiry in Ontario, and started to advocate for reliability standards for expert evidence in New South Wales, something we still don't have. So something about my advocacy relative to your advocacy. And I read Emma's book and got to know Emma as well. And so that was kind of interesting. And then I started to have kind of, I guess, concerns about the case and concerns about the evidence of the forensic pathologists in the case as well. I was kind of, you know, I was concerned about things like why it is they could give evidence about improbability of the deaths, as forensic pathologists? What is it that a forensic pathologist knows that could allow them to talk about that in a way that's beyond what an ordinary person could kind of make of that? But really, you want some statistical evidence of these sort of things if you could get it. So I was kind of worried about the evidence and the way it's put forward. And over time, as I'm kind of in a very kind of a role that I'd call more cameo than leadership, I started to support the kind of calls for the review. I was shocked at just how slow this process was, how insensitive the courts are to things like people who stand by people. That doesn't happen to many prisoners. People that invest resources and time, independent experts that get involved, no interest in the case. Like courts just treat this as nothing, or biased and partisan people. Leading pathologists got involved and supported the kind of case, and they were just treated with contempt. And I guess I'm going to not say too much here, but the failure of the system still kind of frustrates me to deal with this other than just something that just worked its way out appropriately. If you look at it, this is an unusual case in many ways. There's a lot we can take from it. My count is that 21 judges of the Supreme Court of New South Wales at one point or another, or former judges at one point or another, were involved in running the trial, in interlocutory appeals, in refusing leave to appeal to the High Court. None of them saw any kind of problem at any point up until the very end, when basically petitions were put forward by the Academy of Sciences, and this was a very open public sore that they need to resolve. And so it was only then that it seems like it was just a way of getting rid of a public problem. And even in the final decision where she was acquitted after the second inquiry made that as a strong recommendation that there was undoubtedly doubt about this conviction or these convictions, there's still no sense, and this is very different to Canada, of culpability, responsibility, or an apology. So it's just a begrudging, okay, you're acquitted. The evidence seems to go that way now. And no reflection about whether there was any responsibility of the court or anything done wrong at any point by the court. And so it's over now in New South Wales, it seems, because there are no lessons. It's like there's nothing learnt, because it was just like that. Oh, the evidence came out at the end, shows she's probably not guilty, and there we are. And that can't be right, because there were people challenging the evidence, advocating, showing there are fundamental problems, kind of irregularities in the case all the way through, and they seem to be just washed away.
Thanks, Gary. A couple of things that I'll add to what Tracy and Gary have shared. First of all, I'd really like to acknowledge Lisa Gord is here tonight. She was the copy editor for Murder, Medicine and Motherhood and made a huge contribution to making the book better. And so it's so special to have you here today, Lisa. Thank you. The second thing I want to acknowledge is that Gary and also Stephen Cordner, who's the eminent forensic pathologist, one of the eminent forensic pathologists that Gary refers to, as well as John Hilton, another, took a gamble on a young legal academic who was making a pretty big claim. When Murder, Medicine and Motherhood first came out, I was very junior. It was based on my PhD work. And both Gary and John Napier Hilton signed on to a letter I wrote to the New South Wales Attorney General in 2011, identifying the basis for my concerns about the conviction. And I want to acknowledge the generosity in doing that. It was important to have, full professors in relevant fields who are prepared to endorse the work of an assistant professor in Canada. But I also want to point out that at least as early as that time, the New South Wales Attorney General had official notice of the basis that ultimately became a core basis for the second inquiry's exoneration. And we know from Johan de Flu's testimony in the first inquiry that there was internal to the New South Wales Public Service advocacy that there should be an independent review of the evidence in the case, and that never happened. The other person I want to acknowledge is Stephen Cordner, who wrote a very warm, very positive review of Murder, Medicine and Motherhood in the Australian Journal of Forensic Sciences. His in my eyes, the leading light in forensic pathology, honestly, worldwide. And so to have his endorsement was tremendously important, certainly to kind of my confidence in the work I've done. But he took that further when the Folbigg legal team reached out to him in 2013 to ask him to become involved. He did the most remarkable expert report where he did the evidence-based work that should have been done prior to the trial. And his report, I think, was about 80 pages long. It was his preparedness to step up and to put his medical reputation on the line that was, I think, an important waypoint to having the case at least start to be taken seriously by the system. So I just want to sort of acknowledge, the courage of people who did put their reputations in the service of inviting the legal system to take claims of innocence seriously in this case. I also just want to recount the circumstances by which Kath received a copy of the book and then Trace ultimately kind of received those photocopies because it's interesting in itself. When I'd finished Murder, Medicine and Motherhood, and before it had been published, I faced a decision, I guess it's fair to say. I'd reached the conclusion that she'd been wrongly convicted, and the question was, what were my ethical obligations and what were my responsibilities having reached that conclusion? And I decided that at the very least it was important to ensure that she was aware of my work and my conclusions, and that she had the option to make a decision about what she wanted to do with that. I reached out initially to her legal aid solicitor who'd represented her through the trial and really received a very discouraging response along the lines of the case is done, the legal system, the legal approaches are exhausted, leave it alone. I didn't feel it was right to move forward without connecting directly with Kathleen first. I'd been careful not to reach out to her while I was doing the work because I wanted it to be a fully independent review of the evidence in the case. So I, through a colleague, Deborah Parks, found my way to Debbie Kilroy, who is an absolute hero of the abolitionist movement that founded Sisters Inside in Australia, very similar to EFRI, very similar role to what Kim Payne has played here in Canada, for those who are familiar with the movement. And Debbie found a way to get me in touch with Kath. My first letter just told her that I'd written a book. What a strange letter. And that I'd concluded that she'd been wrongly convicted and asked, did she want a copy of the book? Did she want to know more? What could I do? It was a very strange letter to write. The response I got was, yes, she'd be grateful for a copy of the book, but she couldn't receive a hardcover book. So I had to print it out for her because of the circumstances of her confinement, which I was, of course, happy to do. But then it asked a question that really, for me, cast this into devastating clarity. What she wrote was, I've learned in here that hope can kill as much as enliven. And so I need to know what you plan to do with this. Is this just an academic exercise, or will you help me? And of course, my response was that I would help and that I would do what I could to draw attention to my conclusions. And for the subsequent kind of 12, 13 years, that's exactly what I did. But it was an important moment when the stakes of academic work became very clear and very human and very important. And the question of what does one do in a moment like that became very real for me as a young academic. So I sort of just wanted to share that I think there are a lot of people involved in this case who had the option to step up or not. Trace is clearly one of those, and that Kath would still be in prison if people hadn't stepped up when they could have chosen to step away. And that's certainly true of Carola Bingwesa, who did the genetic work that ultimately provided an alternative cause of death.
But on saying that, on saying that, I think one of the...
I don't think that makes any difference to us. Maybe it's for them. Yeah.
It does to them, yeah.
I think one of the important points, just to follow up on that, is that my sense is that notwithstanding the kind of effort and the tireless effort that some people put in and the resources that were invested, it's luck in the end that gets around. It's just the fact that the Academy of Sciences is able to identify some genes which throw doubt on the prosecution version of events. It's a bit like a person, like a DNA kind of exoneration. And that hadn't existed. It's hard to know what would happen. I'm not sure she would be out of jail now.
Yes.
I'll just say, I'll just add to that. You know, you guys aren't familiar with the case. So I will say that, you know, Emma sort of alluded to it before. The pathology was always there. The diaries and their true meaning and the purpose was always there. And I guess the most beautiful moment for me, because there is literally a cast of thousands of people that have helped bring this case to, you know, the end that we saw with Kath being exonerated. You know, there's people online today, I know, out of my Justice for Kathleen Folbigg group, and there's probably, you know, legal people that have been involved as well. Without those people, we would never have got this. But the truth was always there. And that's the thing that kept me going. What I've always said with this case is the lie of the case became the truth. And once that happened and Kath was convicted on that lie, you were always in a loop. You were in a legal loop you were not going to get out of until something new came along, new and compelling. Yeah, new and compelling. We had to look for that. There was this beautiful moment for me, though, when I said to Rani, our wonderful solicitor, and Robert, one of our wonderful barristers, that surely if the diaries hadn't been done in the first place correctly, which they weren't, they said they were taken as literal meanings of guilt, you know, they were able, worst thing is, I don't know whether any of you have ever seen any of the diaries online, because they're all there for the world to see. They were able to take extracts out of them and then put their own meaning on them. And then that played out really badly in the first inquiry, where someone is asked, you know, 70 odd times whether she killed her children because of what was written in those diaries. But I did say, doesn't that mean that this is new and compelling evidence if we can get proper psychiatrists, psychologists, linguists and that involved? And that made me smile.
Thanks so much, Tracy. And I'm so glad that you mentioned the thing that you do often say, which is that the lie became the truth. For the system, once Kathleen was convicted, that became the bedrock from which the system then operated, and shifting that rock took an enormous amount of effort. I will give you some context for the diaries because they've been mentioned a few times, and I can see some question marks on people's faces. Over the course, after Kathleen lost Caleb, her first son, she was advised by a grief counsellor that it would assist her to keep a journal of her emotions and as a way of kind of processing the loss that she'd experienced. Now, she'd kept diaries on and off her entire life, and Trace has known her since her school days. But those diaries, which she did then continue to keep up to and including the time when she was pregnant with Laura and after Laura's birth, reflected what to specialists in grief and bereavement, and particularly parental grief and bereavement and trauma, recognised very well as extremely expected and normal reactions of self-blame and self-doubt experienced by parents in the womb. So they contain passages in which she asks herself if she'd stepped into the room a few minutes earlier, could things have been different? If she'd parented in a different way, could things have been different? If she'd been more patient with her children, could things have been different? These are the kinds of claims that were taken as being, that at the trial, the Crown prosecutor literally characterised the diaries as a machine to read her mind, and as the best possible proof of Kathleen having killed her children that the legal system could possibly hope for. I think it's also important to say that at the trial, the Crown prosecutor stitched his own words together with the words that Kathleen had written in a way that wouldn't have been readily evident to the jury, which didn't have the diaries in front of them at the time. And that in the second inquiry report, when Kathleen's finally exonerated, the inquirer makes a point of raising concerns about the ethics of that approach. It's one of the few places where he allows himself to step out of the role of simply thinking about Kathleen's guilt and into making a comment about how the system had operated. But Gary alluded, to the ways in which the system has let itself off the hook here. And when the New South Wales Court of Criminal Appeal finally came to decide the case on the 14th of December last year, a new lie became the truth, I would say.
Yeah.
And that new lie was that the genetic evidence made all the difference in the world, that the tremendously important and wonderful work done by Carola Vinwesa and scientists, that the truth of this case could not have been known until there was an alternative genetic cause of death. And that's just abundantly disproven by a mountain of evidence. But a second lie was also told, I believe, in that judgment. Gary's alluded to the 21 judges who looked at this case over time. Each one of them cited the diaries as compelling, some just characterised it as chilling, as terribly persuasive evidence that supported Kathleen's guilt. When the New South Wales Court of Criminal Appeal finally acquitted Kathleen, the one reference they have really to the diaries, they say it's readily understandable why the jury understood them to be evidence of guilt, with no reference whatsoever to the ways in which countless judges had interpreted them over the course of 20 years. And as Gary says, in stark contrast to how the Canadian legal system approaches these moments, no suggestion that there's lessons to be learned or reflection to be done on the part of the criminal legal system about why a young, bereaved, traumatised mother's words were treated so in a way that so profoundly misunderstood what the court was saying, and what courts might seek to understand in the future about women's narratives. And I'm looking at Marjorie Fee because this is all about women's narratives. When they come to interpret the words of women and the ways in which I think, frankly, courts generally are profoundly bad at interpreting the words of women and the narratives of women. And I think this points to a much deeper systemic problem that the court has simply sidestepped.
I think that's great. And I was just going to add, the reliance on the genetics as the kind of the solution to the problem of guilt and innocence at the very end of the case meant that there was no reflection on the change in the diaries and how it was so many judges kind of got wrong fundamentally with the diaries. But it also points to the same sort of systemic issue, which is, confessions, admissions, they're the bread and butter of the criminal justice system. And all of these very eminent judges didn't get it. Not one of them before the second inquiry at any stage asked a question or cast any doubt at all on the diaries as being anything other than the most compelling evidence. They don't it gives you some insight into the system really having very thin understandings of what it's doing.
Yeah. Yeah, and I'll just go to that further. In the first inquiry, which was a train wreck, and I think I'm allowed to say that, it was a train wreck. There was so many dodgy things. I don't even have enough time to even sit here tonight and tell you what happened. And I'll probably get sued by lots of people. But it was really dodgy. And, I put in a submission. It was 59 pages or something. It was basically a lit review. It wasn't my best work because it was done on speed. I'm trying to sort of look after Kath, attend the inquiry and, put in this submission at the end. But the fundamental of it was, this is what complex grief looks like. This is what complex PTSD looks like. This is what journaling looks like in that context of a mother's grief and loss. And it was very clear that there was a lot of writings on that stuff. And it was before them. And then I get a note from the head, second head of the inquiry that we're not accepting your stuff. You're not an expert. And we don't think it's appropriate to show the judge. So, and there was another few of those given in that I am aware of as well, all got rejection letters and they were experts. So what we heard at the beginning of the inquiry, there'd been great pains taken to actually get a forensic psychiatrist involved to do a really good report. It's one of the best reports I've ever seen on Kath's case about Kath personally. And he spent quite an amount of time with her. And he wrote a very comprehensive report. And the judge says, what was his words exactly?
I would not be aided by psychiatric evidence about this woman's diaries, quote unquote. And that too becomes part of the lie, because one of the differences between the first and the second inquiry is that the second inquiry admitted that evidence and sought independent evidence from other experts as well. And so when the Court of Appeal says, well, now the psychiatrists have told us that the diaries don't mean what the jury thought they meant, they don't pause to consider why they thought they meant something different. And that's part of Gary's point. I'd say they also don't pause and think, well, what about all that forensic pathology we were relying on for all those years? How did they get it so wrong? And so there's this it's rare in the legal system to get something approaching a ground truth. In this case, in many ways, we have it thanks to the genetic evidence. That's a gift. It should be taken as a gift to the system, a gift that allows the system to look at its own processes and think about, to the extent that the legal system's often relying on proxies for understanding what the truth of the case may be.
Or common sense.
Or common sense. How did we get it so badly wrong here, and what might we learn for other cases from this instance in which we got it so badly wrong? And there's been a turning away of that from that question across the New South Wales legal system, I would say, since the exoneration.
Absolutely.
I was actually going to propose, we've been talking for some time, and it's a lot, I know, that we give people an opportunity to ask a few questions.
Well, how did the children die?
Fair question. So what we now understand to have happened is the 4 children died in different circumstances. Another kind of problem with the case all along was that those differences were overlooked. The two girls, Sarah and Laura, who were last in the birth order, turn out to have had a genetic variant in a carmodulin-related gene. If you know anything about the genetics of the heart, carmodulin is an important protein for the purposes of regulating the heart's beating. This particular variant was novel. It hadn't been seen in any other family, but was subsequently proven through Carola Binwace's work and others to be clearly associated with sudden cardiac death in infancy. The 2 boys were the first in the birth order. Caleb's death is the one about which we know the least. He only lived for 19 days and he died in 1989 when autopsy standards were not what they subsequently became. That's the death about which, in a sense, we still know the least. Patrick died at the age of 8 months after having been diagnosed with epilepsy. It seems fairly clear that it was the epilepsy that killed him on the basis of the evidence before the second inquiry. Both boys also had a different mutation from the one in the 2 girls that the current studies, and the studies are still ongoing, suggest may be associated again with sudden death in infancy. So it's just terrible, terrible luck for one family to have more than one genetic variant, for one family to see 4 deaths in a single family. But it was that terrible luck that started the case that became sort of everything, in a sense. So much of the Crown Prosecutor's original case was, it's not possible, lightning doesn't strike 4 times in one place, was one of the pigs might fly, was another phrase he used. That never held water once you saw that the deaths were different in their characterisation in many ways. Zach, and then Lena.
I imagine that in Australia, like in Canada, the onus would be on the Crown to prove Miss Folbigg had committed this crime beyond a reasonable doubt, and not just on a balance of probabilities. But to me, it seems that there's something, if they're simply relying on circumstantial evidence of, well, 4 children died, and this is it's improbable. That seems that this would just occur by natural causes. It seems to me that they're just relying on, what is essentially a balance of probabilities analysis. I don't find that it convinces me beyond a reasonable doubt personally, just on the basis of that evidence. I was wondering if you could provide insight on if there was more evidence presented beyond just the circumstances.
Yeah, so I think I'm conscious of all we've skipped over, in a sense, and kind of jumping into the exoneration story. So Zach, the Crown prosecutor's argument had a number of planks. The first was the argument that a pattern of 3 or more sudden unexpected deaths in infancy in a single family was unknown to medical research. That was provably untrue in 2003, and I proved that in Murder, Medicine and Motherhood. And even more so as time went on. But it effectively, I argue, reversed the onus of proof. So in the jury's mind, if such a case had never been documented, then the onus of proving innocence kind of becomes much stronger than if there were other documented cases. The second plank to the Crown's case was a misogynistic reading of the diaries. And in particular, that was tied to both misogyny towards Kathleen. And so in the diaries, for example, she confides concerns about her weight. She talks about her, the psychological term for it is matrescence, the developmental transition into an identity of motherhood, which is particularly complex in circumstances where you've lost previous infants. And she talks at times about her ambivalence, about demands of and her concerns that ambivalence has affected her children. Again, that's all tied into complex grief. But by the Crown prosecutor, that was interpreted, and then he argued that the jury should interpret it as signs that she was a dangerous person to her children, that she was aggressive towards her children, that her ambivalence came out in homicidal acts. The misogyny also came out in the Crown prosecutor's characterisation of the friends who did testify that Kathleen had been a caring and diligent and capable mother. So he characterised them as the girls from the gym and suggested that they had no insight to offer the court about Kathleen's relationship with her children. The last major plank of the trial evidence was coincidence and tendency evidence, which here in Canada, for those who are law students, would be called similar fact evidence. It was the claim that Kathleen had been in the care, had each child in her care, or each child's death had occurred during a sleep period. That completely decontextualised, of course, the gendered pattern of primary caregiving in a family, a nuclear family such as Kathleen's, where effectively, and the evidence was very clear on this trial, Kathleen took care of the children and her husband, Craig, was the breadwinner and didn't attend to the children even when he was home, including at night. And so the fact that, for example, Kathleen was the one to find each of them dead, the fact that some of them died while Craig was at work was simply a reflection of her caregiving responsibilities, but it was taken down to reflect her animus towards the children. So those were the kind of key planks of the evidence. There was absolutely no evidence of violence towards the children. There was no evidence of any harm to any child on autopsy. There was no evidence of any bruises or scratches or any signs of a struggle. So there was no positive evidence whatsoever.
Or a crime.
Or of a crime. Yeah, absolutely. Yeah. Yeah. I think Layla was next, and then I have Don and then Ben.
Actually, Vicky answered one of my questions already, about where was the partner in all of this. I have one quick question and then one that I would hope all of you would answer if you could. The first one was, how many of the judges out of the 21 were male? What was the gender ratio there?
So I think 4 of them, just to be clear, were involved in one conducted the second inquiry and 3 were on the appeals court that actually acquitted her. And there was certainly 1 female on the final appeals court, the Court of Appeal, and I think Simpson might have been involved, so there were 1 or 2 others. So there were very few women amongst that.
The second question that I have for you all is, it seems like you all have some form of disappointment in the system. I don't want to put words in your mouth, so you can confirm or deny that. But do you see the system changing at any point with this trial and this acquittal? And if not, what would it take for the system to change in New South Wales?
for a long time, I grappled with the fact that I kind of was a nobody and the adversarial system had all the power and everything. But I've kind of changed since working with these guys and all the scientists and everything. I realised there's power in the liminal space. So while the Supreme Court stands there with all their wigs and finery in front of us, refusing to admit they got it wrong, and I did let out a gasp in the courtroom that day, while they are refusing to apologise to Cass and to all of us for everything that it's cost and loss, which is substantial, but especially Cass, the most heinous thing. While they're doing that, they have underestimated the power of people like myself in the liminal space. I'm not held over by ethics or legal stuff. I don't have to adhere to all the code of ethics the scientists do in that. So if they think that we're going to go quiet, no, that's not going to happen. And I guess, I was listening to a few people last night and it made my heart sing, that building social capital, there was a lot of political complacency, legal complacency, it even was disdain, I would say, in this case. But I realised in the end, especially in the last sort of 10 years, that you're in the liminal space. You don't have to really worry about that. You can push back. And they made us really savvy in the media. They actually empowered us to be very vocal. And as long as you have your stories right, you understand the case, and you have to understand so much about this, and you also have to take the lead. When you do that, I think in the future they underestimate our capabilities. We're going to call and we're going to keep calling. And I feel pretty strong about that. Like, I'm a bit tired at the moment, but I just say I'm just resting and I'm powering up, because there has to be change. I didn't do this for nothing, I didn't do this for nothing. I always think I've had so many conversations with other wrongfully convicted people as well, and the advocates that have supported them. And it's just made me power up and more determined to call for change. And, I know you have feelings about the Criminal Cases Review Commission, but we've got to start somewhere. And I believe we should start there. But we've also got to proactively manage what happens in the future, so we try and avoid these train wreck cases, right? So I've been talking to Corolla about setting up a foundation where we can source experts really easily. We can offer training to medical practitioners to build expertise in genomic science, for example. We can offer training to legal experts to school them up, like judges and stuff, because how else do we get this professional development? But you've got to make it easy. You have to. So I think we've got to, build in some fail-safe measures at the front end, but not everyone's going to be able to, not actually go through this process and win. There will be some losers in this, and I don't think we're always going to get it right. So we need some sort of mechanism to be able to review, because it is not sustainable to actually expect the legal teams and the scientists and the linguists and the academic legal people and the people like myself, and I'm down 7 figures on this, I'm not joking, to expect people like us to always do it for free. That's a cop-out of the system as far as I'm concerned.
In each case.
In each case.
There's no systemic.
It's a great job for the system itself. It keeps people employed at the high level, but it's not sustainable because people like myself end up losing, and I'm not going to tolerate that. It's not acceptable.
Thanks. So I think I'm quite, I don't know, skeptical, cynical maybe. I come from a jurisdiction where for the admissibility of scientific and medical evidence, there's no requirement for it to be reliable, the opinion evidence of scientists. And so you have prosecutors standing up saying, when the admissibility of evidence is challenged, saying there's no requirement that this evidence has to be reliable. It's irrational and it wastes resources, because that means all the burden is on the most impecunious group, the defendants, to try and challenge this kind of not necessarily reliable evidence at trial. It's hopeless. This the first petition sat on the desk someone for 3 years, and there's, apart from academics, There's no talk about a criminal cases review commission or depoliticising the decisions. You can imagine it's difficult for an incumbent attorney general to actually launch an inquiry into a conviction of, the most hated woman in the country. So you're not going to win votes for that sort of thing. And it's kind of crazy that happens. But it's also unpredictable. You never know how things will happen or might eventuate at times. I mean, even with the intervention of the Australian Academy of Sciences, there hasn't been any talk about institutional reform. We've had a few kind of shared meetings where groups discuss these things, but it goes nowhere. So yeah, I'm not hopeful, but you continue doing the things. I don't know to say much more than that at this point. But I think in terms of systemic review, as I say, and I think about prevention as the kind of important part here, because it's so incredibly difficult to right a wrong in our system. And this is a case of judges just digging in, doubling down, and where there was nothing in it for them to do that. Like, why did they do that? What was the need? And this will be the last thing I'll say. One of the things I think it gives you a sense of is the vulnerability of our judiciary in New South Wales to populism. I think there was very little in it to let this person go free because they would have copped a lot of criticism as well. And so you've got to think about independence of the judges.
And I think that's, again, where the kind of convenience of the genetic evidence is kind of so important. I endorse everything that's been said. The thing I wanted to add is I made a point of mentioning the Marshall inquiry and the changes that have played out in Nova Scotia, precisely because I wanted to say thank you, Leila, for giving me the opportunity to do this, to circle back and to say that even once Kath was exonerated through the second inquiry report, that report, Tom Bathurst, who's the former Chief Justice of the Supreme Court of New South Wales, sticks scrupulously to his role, which is statutorily defined, which is to determine whether there is a reasonable doubt about guilt in this case. And so the inquiry report contains almost no systemic discussion whatsoever about what led to this wrongful conviction, about the misconduct of people along the way, about what might be changed in order that things be different next time. And that is a very striking difference from inquiries that happen here in Canada. That I sort of want to point to, but I also want to say that when I was the research director for the Mass Casualty Commission, one of the conversations we had around the table a lot of the time as directors and with the commissioners was, how do we make all of the money that's being spent on this inquiry matter? If we took $60 million, which is about what that inquiry cost, and gave it straight to the communities that were most affected by this commission, how do we make this commission mean more than that? That was my yardstick for success when we did that work, making it count, making it worthwhile. And I quake at the amount of money that's been spent by the system defending the Folbigg convictions over time and then finally acknowledging the innocence, but also the pro bono efforts of so many people. If all of that could have been channeled into constructively acknowledging that a wrong had been done, and how do we do better next time, and how do we make the system better for those who are now coming through it, we would be in a very different place in the New South Wales legal system than we are. And it's that sort of squandered effort that's part of what's really heartbreaking. It's quite apart from an innocent woman, a bereaved mother, spending 20 years in protective custody. There's so much that's lost when the system digs in the ways it did in this case. I see Gary wants to say something.
So very briefly, we should have had in New South Wales a Canadian judge come down to run one of the inquiries. That happened in New Zealand. I'm not joking. A former Supreme Court judge came down to run an inquiry. I think it's just also thinking in terms of reform. At no point did they even look to another state or jurisdiction in Australia to bring a judge in. So it's all the judges. Some of the judges was like Bathurst, who ran the last one and did a reasonable job. He was Chief Justice when some of the judges in other cases had been sitting in his court. I think it's bad look, and I think it's bad practice. I'm sure there are all sorts of unconscious influences going on that you can't manage. And it's just, why would you do it? I can't understand that these people were appointed, but in some ways it wasn't their fault, or that they could have declined doing the inquiries.
I'll just add, you know, there's somebody else in here going, why am I here? What I'd like to actually add, and this is just a message of hope. You know, I always say, you know, it's why I'm wearing ethical as the new black on my t-shirt. You know, I always say it comes down to each of us to behave way better, right? So for me, the building of social capital in this case, and as I said, it took a cast of thousands, you know, the general public supporters in my closed group, there's nearly 1,000 of them. We've got a few thousand publicly. We've got thousands signed a public petition. We've got all these experts supporting us, right? The good thing about all of that is that we had a group, even though most of them didn't talk, it was like a collective ethics group, if you like. We were all there for the same reasons: integrity, truth, ethics. You know, we didn't even have to have that conversation. They all just believed in doing the right thing. Yeah. And I guess that's in anything that we look at. It all collectively, there's power in that. And I'm not going to lose hope, because we did it once. We can do it again to call for change. We have to drop our egos, and we have to all have a collective dialogue. We're not always going to agree. You know, you guys saw that last night. We're not always going to agree. But if you come to the core with integrity and ethics and truth and justice and all of those things, and it sounds all warm and fuzzy, but it worked here. Okay? That gives me hope that we can do this again. Building of social capital and then advocating for change collectively is important. Yeah.
Thanks, Trace. I've been given the 5-minute warning, so I'm going to suggest Don and Ben, can we take questions from both of you and then just address them collectively?
Sure, I mean, absolutely. I mean, Gary and excuse me, both of you have been speaking to what I've been thinking about, but it is, once the lie becomes the truth, then, because inevitably the resistance, and this probably is the case for all wrongful convictions, the system, the social relations, or indeed the social capital that is the legal system, becomes a major impediment to this lie being overturned. Inevitably, the 20-some judges, all of the folks that are involved, as I think you said, Love, that they don't really, what they have to lose is reputation. What they have to lose is their place within the social network that is the legal system and the social capital that they are protecting. So it seems to me that probably, I mean, the sort of dialogue that you're talking about has to be across these two networks of social capital, so that leads to, hopefully leads to self-examination within the legal system of ways to recognize when mistakes have been made and so on. So it's just a comment, really.
Thank you very much. Ben.
So thank you very much for the presentation and for sharing your experience with the case. It was enormously interesting. I just thank you for sharing this. My question was about the two inquiries and essentially why they have they end up with different outcomes in such a relatively short period of time. So they're held within 5 years of each other, or 4 years of each other, depending on when you think they start and end. And like, I just would like to hear a little bit more about why that happened, why you have two inquiries held within relatively short order of one another come up with different outcomes on such a profound important matter. So I just was curious about that.
You should answer that, but I think the only comment I want to make, just to preempt that, is that the second inquiry obviously has an advantage over the first inquiry. And there's not much in it for shutting it down or not hearing things, and so it changes the nature of the inquiry. So, but why the first inquiry was like it was and the people involved.
Thank you, Ben, for that question. No, all good. So I'm actually going to make a brief comment in response to Don's observation, and then I'll do my best to address the question you've asked, Ben. Don, you're absolutely right, and I think we see when we kind of trace this case through, and we trace the arguments about this case through, time and time again, legal actors kind of making the choice to protect other legal actors over seeking to think about what the truth might be. And right through, including through the second inquiry, including through the ultimate exoneration decision. So that point about how the legal profession kind of closes ranks in the face of external scrutiny, it actually also runs through the Australian Academy of Sciences advocacy, interestingly enough. And the pushback that they kind of initially, like they were really kind of warned off by the legal establishment. And it was only once it became clear that they, as a different kind of elite, were going to entrench on this and they were not going to drop it, that really the ground started to shift. And I think it's not irrelevant that it was an elite organisation and it was 3 Nobel Prize winners and it was 90 eminent scientists. That was what really made the difference. It was elites versus elites in lots of ways. And you know, I think it's important to name that. But Ben, to answer your question about why the 2 inquiries were so different, I obviously can't speak to the motives and the choices made by the official actors in those 2 inquiries. Great opportunity to plug the fact that I have a 2nd edition of Murder Medicine and Motherhood, which will come out and we'll try to tell that story. Thank you for that gift. What I can say is that when one sits down and looks at the transcripts of the choices made by counsel assisting in the 2 inquiries and by the inquirers, one sees that they proceed profoundly different in ways both big and small. And, you know, my responsibility, I think, in writing the 2nd edition is to try to sort of show that and let people come to their own conclusions about what the motivations of the various actors might have been and why they look so different. It's a delicate, difficult task, to be frank. It's been a hard one to write. But there's no question that in really small ways and in really enormous ways, these 2 inquiries proceed profoundly differently from one another, not just as to their outcome, but all the way. But it is time. It's time for us to take the conversation, if you wish to, across the way. We do have a reception. You're almost welcome to join us. Thank you very much indeed.